PIC 4020 famous case. This case is related to a bogus IELTS document. The background of this case is the visa application was refused by Immigration Department onshore, that is in Australia, because the application was lodged apparently in Australia. The applicant had review rights for this application, so went to Migration Review Tribunal, the MRT. But the MRT agreed with the department's decision. So just for your knowledge, MRT could either agree or disagree with the department's decision. And if it disagrees, it will send back the file to the department saying that it disagrees with the decision and would ask them to take a positive decision, that is to grant this visa. In this instance, it agreed with the department's decision, so the applicant went to the Federal Circuit Court of Australia, FCCA, only to find that it agrees with MRT. So they've lost in MRT, they've lost in FCCA, that is the Federal Circuit Court. So the applicant took it to higher up court, that is Federal Court of Australia. So for full details of this case, a link is in the video description. Please click on that and read the case yourself. As I said before, the applicant first went to MRT. So in evidence given to MRT, the visa applicant said that she took the IELTS test whilst on a visit to India rather than in Australia. Now the visa applicant's explanation is as follows. I quote, "The first IELTS I appeared for in India was on 7th March 2009. The IELTS test center was in Ahmedabad, the same city where I was based, and was 20 minutes drive from my father-in-law's house. I was very much confident that I will pass this time, but unfortunately I couldn't pass and got listening 6.0, reading 6.0, writing 5.0 and speaking 6.5. And the result was again not as per the requirement. Please see the result attached. But I didn't give up and said to myself that I can still do it and started preparing again for the next date of IELTS, which was 21st March 2009. Please see the IELTS test registration acknowledgement attached. The IELTS test center was in a different city, this time called Rajkot, which is approximately 4 hours drive from Ahmedabad, the city I was based. I took a public transport to travel there one night before the IELTS test and stayed at my uncle's place. Next day on 21st March 2009, I went to the test center to appear for the exams, which was approximately 15 minutes drive from my uncle's place. As I had failed for the first exam, I was a bit worried about this exam because I had to bring my son to Australia, who was in India for 2 years. I was a bit nervous in the exam, though the question paper was a bit easy. The gentleman who was the supervisor in the examination hall came to me and asked why I was nervous. I told him the reason that I had failed few times before, and he said don't worry, and asked me to give him my old result dated 7th March 2009 and he will fix up the new result for me. When he said he will fix up, I was a bit happy and finished my exam in a relaxed mood. At the end of the exam, I gave him my old result which I was carrying in my handbag. I handed over my old result to him and he said you will get your results for the exams dated 21st Feb in post as normal and you will pass the exam, don't worry. The supervisor introduced himself as an agent of IELTS body, so there was no point for me not trusting him. I was so happy and had travelled back to Ahmedabad on the same day. I enjoyed the remaining 15 days stay in India with family, friends and my son." Judgment by Honourable Justice Buchanan. For the reasons I have already given, so this is Justice Buchanan saying in his judgment. For the reasons I have already given, it should be accepted that PIC 4020 is directed to information or documents which are purposely untrue. It seems to me clear from the same analysis that the purpose of PIC 4020 was to render visa applicants ultimately responsible for the veracity of the information and documents supplied to support the application. Although the limited terms of the waiver and therefore any discretion to excuse non-compliance make it apparent that innocent errors are not the focus of attention. It is equally clear that PIC 4020 is directed at the overall integrity of the visa system and as a bulwark against deception and fraud from any quarter associated with a visa applicant. It is not inconsistent with a coherent public policy to make a visa applicant ultimately responsible for purposely untrue material provided with a visa application. It would be an intolerable burden on the administration of the visa system to require that those assessing visa applications not only discover that information or documents are false in a material particular, but also that the visa applicant who provided them knew them to be so. In many cases, that would be impossible and would defeat the apparent intent of the provision. In my view, it is not necessary to show knowing complicity by a visa applicant. That would impose an impossible task on those administrating the visa system. But it is necessary that the information or document have necessary quality of purposeful falsity, whether or not the visa applicant can be shown to have knowledge of that fact. So the moral of the story here is that the judge is saying that it will be a very, very hard task for case officer and other departmental officers involved in the verification of document to research and find whether the applicant knows about the bogus document or supplied it without the knowledge of it. It will become very hard of it, and that operation will obviously cost more time and money, and they don't have to do it at the end of the day because the PIC 4020 is not introduced for that purpose. It is there for a clear purpose of finding the bogus documents, whether or not the applicant knows about that or not. So the moral of the story, it is your responsibility to see all the documents that you are providing are bogus or not. And for youngsters, my advice is never believe someone who is telling you, look, they have done 50 or hundreds of visa applications, they have provided them bogus documents, and you will be 101 or 51 of them and there will be no problem because they are an expert in this area. So if somebody says that they are bullshit artists, okay, bullshit artist in Australian slang means that who could lie very efficiently and say it so well that you will believe that it is truth. But the truth is, there are many visa applications rejected on the basis of PIC 4020, and you should not be one of them. And if you have fake documentation already with you, consult a registered migration agent and to see that you will not provide the fake documentation and get a realistic analysis whether you are qualified for a particular visa type in Australian immigration. And if you're thinking of going for a fake document, this is the time to stop that thinking and then just focus on whatever documents you have and check your eligibility. If you are eligible, go for it. If you're not eligible, try to get the eligibility rather than buy certificates. Thank you very much for watching this video. My name is Sujith Billa. I'm a registered migration agent here in Australia. If you wanted immigration advice, simply go to my website, sujithtalks.com, and schedule a phone consultation.